Hello all, welcome to the lecture. In today's lecture, we are going to talk about Amicus Curiae. Who is an Amicus Curiae? So firstly, we need to understand this term itself. Amicus Curiae, basically as a term, if we look at this, it translates as friend of the court. Somebody who is friend of the court. And the other term that we can use over here is amicus curiae means neutral lawyer. Neutral lawyer that is appointed by the court. And what it does is it assists in cases which require specific expertise. So there are certain cases where we require the expert's help and where that is the point where the role of amicus curiae becomes important. So they are advocates appointed to assist the court in adjudication of important cases. Amicus curiae is an individual or an organization who is not a party to a legal case, but somebody who is permitted to assist the court. So that person can go and assist a court by offering a lot of things by expertise. When somebody is offering expertise, what does that mean? It is offering information or insight into that particular case, right? Something that could be solved in a particular manner. So that is the role amicus curiae is playing over here. This term, if we talk about, it has originated back in 1605 to 1615, and it is a Latin term. And the complete decision on whether to consider an amicus brief, it completely lies with the discretion of the court. So you will see that the scope of the amicus curiae is generally found in the cases where broad public interests are involved and concerns regarding civil rights are in question. Amicus curiae is required in various situations. So what are the situations where it plays a very important role? Let us discuss that. Firstly, in helping in PILs. In many high-profile PILs, you will see that the court has appointed amicus curiae, and why? What is the reason? So that they can assist the court, help them with their expertise, with their knowledge in formulating a viewpoint and to make inquiries and reports. And in several major PIL judgments that have been done, like on terrorism, or you can say freedom of media, these are very important topics, right? Like prison reforms, and decisions have been based on the assistance that is provided. So you can see that a very significant role, as in the starting itself we were discussing about the friend of the court. And what is this friend doing? It's basically guiding the court in making the decisions, that these decisions should be taken up. Second important thing where it is required is during the investigation, doing the investigation. So in many cases, amicus curiae is appointed in cases that are not PILs, where important questions of law are involved and both the parties are represented, but the court still wants a senior lawyer, right? A senior lawyer who can assist the court that, okay, this should be taken up. You know, there's one case where Supreme Court appointed Raju Ramchandran as amicus to investigate allegations of Narendra Modi's complicity in the Gujarat riots. So you will see that this was one particular area where uh, where the court appointed a senior lawyer to, yes, please assist in a very high profile case that it was. Third very important thing is defending the accused. So the traditional amicus curiae, who is the one who is asked to represent the accused in a criminal appeal. So this happens in two situations. When the accused is very poor, and or we can say he requests the court to provide him a lawyer. For example, that Raju Ramdaran defending Kasab, that was there. Or when the criminal does not engage his own lawyer to defend him against the state, that can be the situation. Supreme Court and High Court maintain panels of lawyers. These panels of lawyers are assigned amicus work in criminal appeals, And the Supreme Court has mandated that legal aid, that is, a lawyer representing a poor accused, is a must in criminal cases, right? So this is another area where they play a major role, defending the accused. A very important case we are going to discuss is in 2019, Supreme Court at that time laid down the guidelines. What kind of guidelines were these? These guidelines were made for appointment of amicus curiae where there is possibility of life sentence or death sentence. Now, Supreme Court noticed that, where death sentence could be one of the alternative punishment. It said that, at that moment, the court must be complaint vigilant and see that full opportunity at every stage is offered to the accused. So that time there was a 3-judge bench of Lalit, Indu Malhotra and Krishna Murai, JJ, that laid down that there should be certain norms that needs to be ensured. So they said, what they said was that in all the cases where there is possibility of life sentence or death sentence, learned advocates were put in a minimum of, the condition was 10 years. So 10 years practice at the bar should alone be considered to be appointed as amicus curiae through legal service to represent an accused. So what we are learning here, that there are certain guidelines that not anybody can become an amicus curiae. Now, if we are talking about the friend of the court, that has to be a person of somebody who is having that expertise, that knowledge, right? And we need to accept them from the particular expert person only. Also, it said that in all matters dealt with by the High Court concerning confirmation or death sentence, senior advocates of the court must first be considered to be appointed as amicus curiae. So these were the recommendations that were made. And it also said a very important thing is, whenever any counsel is appointed as amicus curiae, some reasonable time may be provided to enable the counsel to prepare the matter. So that friend of the court not necessarily be a one particular individual, but can be a counsel also, because there cannot be any hard and fast rule on that behalf. And there should be a particular time period that should be provided to them, because not in a very haphazard manner they can take up the decision, right? So this is how it gave out this certain guidelines related to it. So what we have gathered over here is that in simplest term, if I have to explain amicus curiae, it is somebody, the friend of the court, who is helping the court in making the proper decision, essential decision. So the lawyer so appointed, he is the one representing the cause, not in the expectation of remuneration, but as somebody who's doing a public service, very important and a major role. And several judgments in the past, if I talk about like mentally deficient digitants or freedom of the media, all these cases there have been there where an amicus curiae has been appointed. So it is considered to be a great honor professionally to be appointed somebody, because recognition is provided to that person, and that person is definitely of a capacity, of an ability and integrity. Thank you. With this, we end the lecture here.